Sunday. Typer. In Macau. And as predicted, and as I spoke a few days ago, they have rearrested Chelsea Manning and they have put her in prison for what they claim is contempt of court on new grand jury investigations into Julian Assange. She will not testify. She will not give any evidence, directing them to their previous court-martial. She served a number of years, 7 years, before Barack Obama freed her, no doubt laying awake at night, guiltily contemplating his legacy as president, locking more people up for whistleblowing than most previous presidents. So, where does that leave Chelsea? Well, the new conditions of her contempt incarceration are not only onerous, but the financial penalties will kick in of some $500 a day for her continued silence. And after a period of 30 days of this punishment, it's risen to $1,000. And if they kept her in for the full 18 months that the grand jury could potentially be sitting, could amount to a serious and substantial fraction of $1 million, over $250,000, possibly more, just to shake the tree and see what falls out. She gave a very good press interview before being jailed, saying that her principles were not bowed and that the pressure they're putting on her will not result in her cooperating with a system that she feels, and I feel as well, is not in the interests of justice. And in America, the US judicial system and the US administration of justice has a fairly unique system of grand jury investigations where only the prosecutor gets to present evidence, only the prosecutor gets to cross-examine potential witnesses, and the grand jury itself, comprising of at least 12 if not more members, more often than not given a one-sided picture by the prosecution, ably supported by a craven judiciary, often agree. And unless you get what they call a runaway jury, where they feel that this system is not delivering justice, chances are that on the flimsy evidence that they're trying to present against Julian Assange as a whistleblower himself, which he is not, he's a journalist and a publisher, quite clearly, quite obviously, from every record we have, every statement we have. So, what can we surmise about their endless pursuit and harassment of Chelsea Manning to the point of denying her any form of legal representation against a judge, grand jury, because they know She's already been charged and sentenced for her offences, they claim, against the Department of Defence. So they can't charge her with anything new. And her defence, if she were called to give evidence, as she is, to claim the Fifth Amendment, for which she would have a right not to incriminate herself, let alone anyone else, is denied her because they said that they would grant her immunity from any charges, therefore negating that constitutional right. Then her other constitutional rights, the right under the Fourth Amendment to be protected from these services, are being infringed, and her Eighth Amendment right against cruel and unusual punishments and unjustified financial penalty of such fines and excessive bail are denied her because she is being held by the judge and the grand jury. To override the human and constitutional rights that Chelsea Manning would enjoy under a more thoughtful and respectful of the Constitution administration, Justice Department, William Pelham-Burr, the Attorney General, and the judge himself, the grand jury, not unlike the British judges that we often see recently in the cases against Julian Assange, are more concerned not with justice but with punishments, coercion, physical and mental torture, financial penalty and bluff that the American Department of Justice are using to intimidate and silence Chelsea Manning from continuing to speak about the things that she revealed and the war crimes that are being committed and have been committed by both the US and the UK and others in countries such as Afghanistan, Iraq, Libya, Syria. It's a long list and the list goes on. Well, we shall see if there's any respite for Chelsea Manning, because she really doesn't deserve to be treated like this. No one does. No one should be treated, held in limbo at the whim of a secretive, unchallenged grand jury system. And I think rightly her criticisms of it, the secrecy, the lack of defence lawyer to put the case maybe against such a pursuit of these charges, which we won't know until the grand jury actually finally decides whether they can up the charges against Julian Assange from hacking to espionage, and if they could, treason. But the only reason they don't use treason is that you can't be treasonous if you're not an American citizen. Thank God. Julian Assange, firstly, is an Australian citizen, not much use. Secondly, an Ecuadorian citizen, even less use now the new administration have decided that he's a complete and utter troublemaker. So we shall see. I'm back in London after the 27th, and I shall be trying to catch up with the hearing at the Westminster Magistrates Court on the 30th of May, where Uncle Sam and his British lackeys will be presenting a case for extradition and ignoring human rights, ignoring so many conventions of the United Nations. It'll take a book to list them, and as the Code Pink protesters in Washington DC have found out, that even the international law protecting countries' diplomatic status and property have been overridden with bits of paper without headings and a legal enforcement that has no grounds, either in international law or American law. And these things, I think, between the British justice system, the American justice system, and the reawakened, dormant Swedish justice system, bode very ill for the likes of Julian Assange and for whistleblowers such as Chelsea Manning. EF Press update on the Sunday.